morning on a scheduling hearing. May we have announcements of council?
Good morning, Your Honor. Bill Hicks, John Davis, Rebecca Torongo, and Michael Williams on behalf of the state of Texas. We are present and ready to proceed.
Good morning, Your Honor. Mark Stevens, Felix Valenzuela, and Joe Spencer on behalf of Patrick Crusius, and we're ready, Your Honor.
Before we go into this court's scheduling hearing, the records reflect that since this hearing was scheduled, this week, the defense has filed a discovery status report, and they have filed a motion for discovery, basically asking at some point for a dismissal of the indictment. The court will touch on those motions at the end, before we finalize today's hearing, but we will be going into our scheduling hearing. Mr. Hicks, the state has always been of the opinion that they're ready to go forward. I need to ask you for an update if that's still the case. But in the defense's discovery status report, they do indicate that since our last hearing, there's been more discovery that's been produced to the defense. Did I read that correctly, Mr. Spencer?
Judge, the only thing we have filed or turned over since then have been, we've filed business records. We have turned over just very limited amount of additional data, very, very limited. Maybe a report or two, but just, we filed business records. But those are business records which have already been turned over.
Did I read the status report incorrectly, Mr. Valenzuela?
Yes, Your Honor. And we actually have something to make it helpful to get through the status report.
We'll get to it then. The state's position on scheduling.
Judge, we are ready to proceed to scheduling all pretrial matters, and we're asking the court to give us a scheduling order with scheduling deadline for pretrial motions, and then a scheduling order for hearing all pretrial matters, to include hopefully a deadline for turning over proposed jury questionnaires.
Mr. Stevens, Mr. Spencer, Mr. Valenzuela, the court did wait almost 6 months since our last hearing, because at the last hearing you indicated the amount of time, at least 6 months, to sort through the discovery that already had been provided. Please give me an update at this point as to the defense's position on scheduling and where you're at with the discovery that you have present.
Thank you, Your Honor. And if I may please the court. Judge, when we came in February, we set a plan out before the court as to what we plan to do after February and where we would be by September. And I just briefly want to go through some of what we've been able to accomplish in that time. So first, as the court is aware, when we were here last year, we showed this slide to show what type of production we received, when we received it, and how much there was there. We had about 2.4 million files through 264 productions, and that was as of February this year. Now, what we did with that in the time being since February is we took what they provided us, and then we gave it over to the vendor that the court had here on the witness stand last time, Mr. Cooper. And what he was able to do is take the 2.4 million files, reduce it down to about 220,000. So it went from 11 terabytes to 0.3 terabytes. What that means, it's a reduction of 93%. Now, this is important in certain respects. First, there's two different types of data that's in discovery. There's something called manual natives. Manual natives is discovery that we manually have to review, such as videos, sometimes forensic reports. And the reason why is that we can't search through a video for certain actions or individuals walking or whatnot. We actually have to have individuals sit there, review the videos, review the surveillance, review the footage to see if it has information or evidence that's going to be coming before the court so we can prepare our defense. As the court saw, the 2.4 million files that were received was unstructured, meaning there was no table of contents, there was duplicative productions, and there was even duplicates within each production. And so what that means is that when we gave it to the vendor, he had to start from scratch. He had to start from day one, trying to get through all the 2.4 million files. So what happened then is we provided the court with kind of this outline of what our 6-month plan was. And this is the slide we showed the court last time. First was to organize the mess. Thank you. First was to organize the mess that the state gave us. And the way we did that is we did some preliminary sifting through the evidence to be able to get rid of easy duplicates. Now, as the court saw from Mr. Cooper's testimony last time, sometimes it's hard to determine what a duplicate is because sometimes they print it, then they stamp it, and then they scan it in again. And so even though it's the same document, the computer sees it as different documents. So we were able to sift through some of those and remove duplicates just to make the process more efficient and less costly. And so we were able to organize the DA's mess. Then what the vendor was able to do is make it comply with just the basic standards. And what that means is adding a load file, creating a table of contents so we can get through this a lot quicker. It took our vendor 4 months straight to sift through all the discovery, the mess that the state gave us, to put it in some kind of recognizable format for us to be able to start reviewing it. And so now that we have it complied with the basic discovery standards, we started going through the process of loading it onto a platform to review. Because as the court might recall, when Mr. Cooper was here, his method was more as a mailman, to sort everything into the proper mailbox. Now it's our job to actually open it and read it and review it and prepare for trial. So even though we're able to sift down, reduce the number significantly, we still have a long process ahead of us in this case. And so that's why today we're here to inform you as to what's left to do. The manual natives that we have to do, given the extent of the team, the resources, the man hours that are required, because the state didn't do that work, so we have to do the work for them, we're suspecting it'll take about a year. It'll take about a year to 15 months to be able to accomplish that. It's thousands and thousands and thousands of hours, that, as you'll see, that we have to get through one by hand. On top of that, we have the rest of the data that can be loaded into the platform, that can be reviewed by the discovery platform, and that's going to take us about 7 months to a year to accomplish. So we're thinking about 15 months to about 24 months is what's going to take us to get through the mess that they gave us, now that it's all in a structured format, and to be able to review it as if from day one, if we could have started this back in 5 years ago. And so that's
Mr.
where we're at with this
Valenzuela,
case.
real quick, before you go on, in June of 2022, Federal District Judge David Guadarrama scheduled the federal trial for January of 2024. Is it your position that at some point you didn't have to go through this because you learned at some point early on that that may be resolved short of a trial? Because I'm trying to put your 15 months to 24 months in context with the federal jury trial that was set.
I think it's an excellent question, Your Honor. One thing to keep in mind that's very important to segregate is that the federal government gave us organized discovery with a table of contents, with indices, with something called OCR, optical character recognition, so the computer can read it for us. So we were able to get through the bait stamped evidence very, very quickly. And that's why we were able to resolve that case so quickly. In this case, we have the complete opposite. It's everything thrown on the floor and kind of a mishmash, all thrown in a bag everywhere. So that's why it's taking us longer to get to a point where we can start reviewing this discovery, because it took us that long just to take their mess and make it look like the federal government, like what they gave us. And that's why there's been a difference in that, Judge.
Go on.
That's all I have for right now, Your Honor.
Mr. Spencer, Mr. Stevens.
Your Honor, you indicated that we had filed a motion that's going to be heard at some point. And it really was a discovery request motion, is what it is. And we've laid out all the different aspects that is missing in discovery, that as a result of our discovery and our investigation, we have found lots of information that is lacking and missing that the state had not provided. We told you from the very beginning that we thought this case permeated in politics, and it started with the Rosales administration. You just heard from Mr. Valenzuela the discovery we got from the state, and back then we told you there was nothing short of paper sabotage by the state of Texas in the way they handled it to us. There is a tremendous difference in the way we got the discovery from the federal government than we got from the state government. There's no excuse for getting it the way we got it. In truth, Judge, this case, as you know, was not written over to the state case until September of last year. So you have had it for a relatively short period of time, simply because there had been federal custody. So as a result of the investigation that we've done, we filed this motion requesting for additional discovery.
Let's stop right there.
Yes, sir.
Are we done with regard to any updates on scheduling? I do want to touch on this, but I know this.
There's some issues in here, Judge, that going to touch on scheduling that we
Okay.
want to get to.
Okay.
So, under the Rosales administration, and Judge, I have to put this on the record simply because this happened so long ago that people forgot about what Yvonne Rosales did and the mess she created as a result of this case.
Let me stop you again
Yes,
right
sir.
there. Unless I'm reading the dates wrong, you have made a claim that the district attorney's office has 3.5 hours of recorded conversations.
Correct.
Between your client and his
Defense
defense
team.
team.
Correct.
It appears that those recordings were gotten during the Esparza administration, or am I reading the dates wrong?
And I'm going to get to those dates real quick for you, Your Honor. And I think you're actually correct.
Okay.
On that, although I think it's a combination. I think Ms. Rosales took it in January 1st of 2021.
That's correct.
Yeah, and I think some of those are in 2021. We're going to get to that in just a second, Judge.
Mr. Hicks?
I'm sorry, Judge, but again, we need to take all of these issues up during the hearing on the motion for additional discovery. I don't know how that's going to be relevant to what we're talking about today, which is scheduling.
The court is, I think we're almost done with schedule, but the court is going to touch on this motion. The court does not expect the state to have to respond, but I'm going to let Mr. Spencer go for a while before I talk about this motion and what I intend to do with this motion.
Your Honor, and just so the court's clear, we intend to file an additional 5 or 6 discovery motions that's going to expand more on the requests that we're making, and it'll lay out the case law in much more detail. So those 5 or 6 other discovery motions that'll go in much more detail to the court will also help the district attorney find out what they have not done and what they should have done and what they still need to do, so we can get this case on track. You know, the DA's colossal disaster was marred by incompetence and scandal. That was talking about Rosales' administration, because it was an absolute disaster. And, you know, Mr. Briggs was actually asked when he was on the case to be part of that criminal and civil conspiracy, and he refused. He refused to be part of that conspiracy, both the criminal conspiracy and the civil conspiracy that Ms. Rosales and her administration started. And as a result of that, Mr. Briggs was wrongfully terminated, and he was fired. So what has happened was, once he left there, then the disaster grew worse, because then there was nothing keeping the Rosales administration. As a result of what Ms. Rosales kept calling the press conference, very similar to what Mr. Hicks likes to do, and talk about this case and talk about what needs to happen in this case, you issued a gag order because you thought this case cannot be tried in the public, and they are constantly getting before the public. And you were very clear in your gag order. All attorneys, their staffs, and law enforcement officers involved in this case shall not discuss the case with the media. Shall not discuss it. You're very clear. Attorneys, not there's a gag order, but let me tell you about the case. You know, it was not to discuss the case. We have honored your rule and your order and the letter of your order in the spirit in which you intended it. What did Mr. Rosales do with witness intimidation? All of the attorneys and the staffs, the officers that were involved in the case were under your order. And here you are, here she is with Roger Rodriguez, who we still haven't been able to track down and get further information. After the gag order was issued, what did she do? She called the victims into the DA's office, and she started telling them, you need to file a complaint against the judge. We got to get the judge recused. This gag order is not right. Roger Rodriguez encouraged in front of Ms. Rosales. Mr. Briggs tried stopping that, give him credit for that, but it was Ms. Rosales' administration. She let Mr. Rodriguez go on, and it was a disaster. Then he meets with a Hoffman multiple times, and they do a conspiracy to misrepresent information to the court and to the community about their involvement and about the involvement of these other conspiracies that are out there. Wild conspiracies, Your Honor. And you heard it because you heard many of that, a lot of that in the hearings before that. We knew that there was something amiss because what ended up happening is Ms. Rosales, through her office, and we believe it was Mr. Roger Rodriguez, sent emails allegedly taking the part that they're the Hoffmans. And what did they try to do? They tried to, again, attack the court and the integrity of the court. The misconduct of the Rosales administration on the community and the victims has a chilling effect on all potential witnesses. They told her, don't answer the calls so that we can tell the judge that you're not answering the calls. They asked her to join the conspiracy. The Hoffmans refused. Thank God that they knew something was wrong. They followed their gut instincts, and they recorded Roger Rodriguez. Had they not recorded those threats, those intimidations, we would have never believed it. As we talk about it in this courtroom, all of the lawyers here have never seen anything like it. We could not believe the type of misconduct that was done by the district attorney's office. It's the same office that Mr. Hicks holds. You can't just say, well, that was under Mr. Esparza's administration. This happened under the Rosales administration. Therefore, I get a mulligan. They don't get a mulligan in death penalty cases, Judge. They're responsible for the actions of what the DA's office did. I'm not holding this administration responsible for Ms. Rosales' action, but it is the office, Your Honor. And they don't get to say, forget about that, because they don't get to benefit from their wrongdoing. So you issued that gag order because it was very clear that what we wanted to get to. So now we're talking about Sixth Amendment rights, and now we're getting into the area that you were specifically asking about.
Okay, let's stop
sorry,
there.
Judge.
Let's stop there. The court's going to discuss this. I have read your motion. There are very concerning claims that you've made. This court is going to have an entire day in October, and I'll tell you what the trial date, the court date is in a while. But this is what I want done until that time. Anything in the DA's office needs to be preserved. I don't expect you to be able to argue this motion at this time. Not only do I want it preserved, you need to start looking at the request that the defense is making for certain discovery. At that hearing that I'm gonna have, I'm gonna ask line by line, item by item, does this item exist? And if it exists, then we're going to discuss whether it is discoverable and producible to the defense or not. The two items that I do want produced immediately are the 3.5 hours of recorded conversations between the defendant and his defense team and the call logs that were produced by the Sheriff's Department to the District Attorney's Office. I want to make sure I understood your motion, Mr. Spencer. One of the orders was issued by Judge David Guadarrama, and 2 of those orders were issued by this court with regard to the call logs? I think that's what I read, but I want to make sure.
I think that's correct, Your Honor. I think that's correct, because I don't want to misrepresent to the
And
court.
so I want those produced as soon as possible to the defense, so they can look to see what, if any, violations of their client's Sixth Amendment right to counsel have been.
Well, there's been 15 violations. Let's not leave that. And it
don't
has a
know-
chilling effect on our ability to communicate
I
with our
understand
client.
that, but I don't know whether you know exactly what those conversations had, because they were 4 years ago. I don't know what they are, but you need to look at them so that we can start having not only hearings, but probably evidence, witnesses at that time too. Those two things need to be produced immediately. Everything else needs to be preserved, and for you all to be ready to argue its existence or non-existence. We all know what happened in the Rosales administration. We all know about the audio tapes. I don't know whether or not there was an internal investigation conducted by the DA's office into those matters, or whether you have been contacted by any law enforcement officials regarding any investigation into those matters. Those are some of the items that the defense is asking to see if they exist. So your roadmap for the next hearing is the request of each and every one of the items that at this point he's requesting, and apparently there may be more motions filed in the future. But we're not in a position to see how far and wide these claims go that we need to resolve. This is not gonna be part of my scheduling order. This is separate and apart that we're gonna do this year. How long will it take you to be ready to prepare for this hearing regarding this matter?
Judge, there were 4 recorded calls. They've already been turned over, and after turning them over, we destroyed them. We don't have those calls
And
anymore.
what I'm saying is,
And
I'm not gonna take this piecemeal.
I
I'm not
understand.
gonna do this now. He's alleging 15.
And
In October, I'm gonna ask, talk to me about the 15, and you're gonna tell me there were 4, and this, that, and the other. But,
and the call logs have already been turned over,
okay.
and so the defense already knows that. But we will look for anything else, but we are unaware of any other recorded calls.
And that's fine. Those are the only 2 items that I want produced immediately. Everything else
Absolutely.
needs to be preserved, and you need to prepare to go line by line with each request to see if it exists and whether it is discoverable by the defense.
Yeah, and we went beyond that. We went, who listened to it, who asked to listen to it, how was it discovered, what was the chain of custody of the call, how was it siloed, if it was siloed. I mean,
Every one of those matters will be asked by the court at the hearing that I'm going to have.
All that information on those 4 calls has already been disclosed to the defense. We'll be glad to go over that again with the defense and in the court and at the hearing.
And I see 15 in here. That's the only thing, and instead of doing it piecemeal now, and Mr. Spencer wants to continue to go forward and you want to respond, this matter is going to get its own day. I really don't need to hear anything else, Mr. Spencer, but you may want to, so let me know why
Well,
we should continue. Go on.
Yeah, thank you, Your Honor, thank you. So we'd like all jail calls, not just the 4 that they've alleged, that we know that there's actually 15, but we'll educate them on the 15 phone calls that they recorded on there. Because we also have, Your Honor, they've asked for attorney, that's a violation of the attorney-client relationship. They're asking for logs of our visitation. They specifically made that request. They have to stop doing that. They cannot do that, Your Honor. It is none of their business, and it's a violation of our client's constitutional right. They subpoenaed records, and they're asking the jail to turn over records that they're not entitled to at this point. They've had improper mental health contact, notwithstanding the fact that there have been orders to that effect, that they're not allowed to have mental health contact with our client. It has come to our attention in Mr. Crusius' cell, he's a folder that says attorney-client privilege communications, that someone went into his cell and reviewed his folder and then threw it back at him. We need information on who instructed those individuals to do that. We have issues of spoliation of evidence, Your Honor. So what do we have? We had 2 separate orders where the jail was instructed that they were to preserve and record Mr. Crusius' actions during the time that he was in custody. That was not done. We have approximately 20,000 hours of surveillance video that were destroyed or that are missing, approximately 2.5 years worth. And why is that important? Because that's important to show Mr. Crusius's mental health, lack of mental health, what he's going through in that cell. It's mitigating evidence. It's Brady evidence that they have an obligation to preserve that has been destroyed. And we have painfully been asking for that. And we are very concerned that we have more than 2 years' worth of video evidence that is mitigating and helpful to the defense that has been destroyed.
Again, Judge, we clearly need a hearing on that because that was specifically agreed to by the defense, by the lead counsel for the defense, that was not needed. That's 24 hours. The defendant is recorded 24 hours a day. No one is watching that video from the defense or the state, and that was specifically agreed to that they don't need that recording. It's not held by the jail if it's not reviewed or requested after 30 days. The defense specifically agreed they did not need that video. So we clearly are going to need a hearing on that. That's a salacious argument.
Yeah, I have no idea where you got the idea of that, because we specifically have an order for the preservation of those videos. It's there, Judge. It's been signed. You signed the order. We had 2 orders that were done. Any information that's Brady material, and you know Brady very well, they have an absolute obligation, along with the Michael Morton Act, to turn it over. To turn over anything that's mitigating and anything that's Brady or exculpatory. We found out from investigating some of the witnesses that the state, their attorneys, and their investigators have investigated that they gave information to the state prosecutors and their investigators that's very favorable to us, that's mitigating, that they have not turned over to us. That's just an absolute violation of basic Brady, Your Honor. I will tell you that when some of the witnesses that we've interviewed talk about seeing Mr. Crusius when he was young, hitting his head on the sidewalk, loudly banging his head, talk about his cognizant defects, talk about his mental health, all of that, those witnesses said they told the prosecutors and the investigators. None of that information has been turned over to us. We're asking that information be turned over to their notes be turned over to us. We also understand, upon information and belief, that there was about 5 notebooks of handwritten notes of investigative work after they interviewed witnesses that we have not seen. We're requesting that as well. And one of the most egregious things, there's so many egregious things, but when the federal government turned over the discovery to both the state and to the defense, they took great pains in watermarking that information. And they watermarked it because they said, we're going to give you this information, and we're going to watermark it so that you know, because there's a federal protective order, and now there's a state gag order, that if any of this information is disclosed, and under the contract we have with the DA's office and the portal, none of this information can be disclosed to a third party under the federal protective order and under the contract with the portal. And the federal government said, we're going to be able to tell if it gets out in the public domain who leaked it. So what do we have? So now we have found information that's on the internet. Information where you've got, obviously, the Department of Justice seal on there, information that they provided and turned over to the state of Texas that is now in the public domain. Even says, no release per judicial order. But then they go on and they actually talk about, at this presentation, information that's in evidence, that's in discovery, that's in the public domain. Why would they do that? Why would they do that? He talks about that he fell asleep. He talks about that he had a gun, he would shoot himself. He talks about that he was, that he's at high risk for suicide level. I mean, they have this information out in the public domain that clearly, where it's coming from, that's a violation. They talk about his mental health issues.
Judge, not to mention, obviously, that time period that he's talking about was back during the Rosales administration, something we'll have to look into, although I don't know if that was released to the defense or not, or who had control of that information. But again, we're going into matters that need to be taken up during the hearing, and are issues that I don't have the ability to answer at this point. We would ask for 30 days in order to be able to respond to all of this. This is issues that I don't have the ability to respond to at this time.
Your point is well taken, Mr. Hicks. This court has heard the update on everybody's position with regard to scheduling. This court is not entering a scheduling order today. This court will enter a scheduling order in this case before the end of the month. And it will be provided to both parties and filed in the court file. This court is going to have a hearing on the defendant's motion for discovery October 31st, 2024 at 9 o'clock. Be prepared to spend the whole day because we will be going through that order. And there may be other motions that are filed between now and then, but the one that is going to be heard on October 31st, 2024 at 9 o'clock is this motion that Mr. Spencer has been discussing. As I've said, preserve everything that is currently in the DA's office. Start looking at this motion because it will give you the roadmap as to what we're going to be looking for with regard to the defense requests that they need. But the two things this court wants produced immediately are the ones regarding this defendant's Sixth Amendment rights.
Your Honor, are you going to have the state, are you going to require the state to respond in writing to our motions? Or are they just going to show up prepared and they're not going to give us any sort of response beforehand? I know they're coming up and they're telling you, you know, we're not ready, we're not ready, we're not ready. Many times they do call press conferences and say we're ready. They're not telling the court they're not ready for this motion. So they're going to get prepared for the motion along with the additional motions. Are you going to require the state to answer in writing any of our motions? Because I know under the civil arena, when opposing party doesn't file an answer to a motion, then it's deemed that they accept the motion. In a death penalty case, I would think that the state should be required to answer our motions in writing so that we can have a roadmap as well and find out exactly what the state's position is and whether or not they're dealing in fact or fiction to the court.
At this point, the court's not going to require the state to respond in any manner except to be prepared to respond by October 31st. That may change in any future motions for discovery or any future motions, but at this point, if it is your desire to respond by written motion, by written response, so be it, but at this point, the court's not requiring it.
Thank you, Your Honor.
Mr.
I need to address the violation of the gag order, Your Honor, because it's going to, you got till October 31st, we're going to have 31 more press conferences that Mr. Hicks is going to call. Judge, you made a point when you issued the gag order on February 23rd of 2024. You called us in chambers and you told us very clear, in no uncertain terms, I have been very liberal with the violations that have occurred in the gag order between both parties. I have been patient. However, I am putting both of you on notice. I said, from here on forward, I expect you to follow the letter of the law of my order and not violate the gag order. You recall that, Judge, because Mr. Hicks and the defense team was present when you said that. And we have constant violations of the gag order by Mr. Hicks. He gets on podcasts. He talks about, and he loves saying, there's a gag order, but let me tell you about the case. And let me tell you what has to happen in the case. And let me tell you why it has to happen about the case. Those are blatant violations. Judge, they don't get to benefit from their wrongdoing. Is this court going to do anything about those violations, or is the court going to allow him for another 45 days to continue to hold press conference about this case when the defense is following the state's gag order?
Hold on, nobody, I'm talking. Mr. Spencer, this motion was filed 3 days before this hearing that this court scheduled for something else. You have made claims against the Esparza administration, the Rosales administration, and the Hicks administration. This court is scheduling those matters to be resolved on the date that I have announced today, and that's when we're going to do that. We are adjourned.
Thank you, Your Honor.
Your Honor, may I add one thing just for clarification?
Yes, sir, Mr. Stevens.
We've heard about, it's a matter of the phone calls. We've heard about 4 phone calls, what Mr. Hicks says today. We know there's at least 15. And What we don't know is how many more there are. So we would ask that, in light of what the court specifically instructed, could we go beyond the 4 and the 15 to everything they might have recorded in violation of the attorney-client privilege?
As I've said, everything needs to be preserved. We know at least 15 have been alleged by the defense, and under Brady and under 3914, if they're aware of any more than the 15 that you believe you know about, those matters need to be brought to the court's attention at the October 31st hearing.
We're only aware of 4, but we will look for these 15 and we'll follow up appropriately, Judge.
We
Thank
are
you.
adjourned. My coordinator will have court settings for you all.
Thank you.
please. You see that, thank you.